The Senate must determine whether to remove a president duly elected by the people. A decision of such magnitude deserves, first, full consideration of the procedures, two, merits of the charges, and three, the ramifications removal would have on our republic. The framers of the Constitution granted the House of Representatives impeachment powers, yet cautioned against using that power unless absolutely necessary. Impeachment negates an election in which Americans choose their leader. If substantial numbers of Americans disagree with removing the president, removal damages civic society. It follows that the House should conduct thorough and complete investigations, even if time-consuming, before impeaching. A thorough investigation educates Americans that a president should be impeached and removed. Failing to convince the people invites anger towards, disdain for, and abandonment of the democratic process. The framers also required a two-thirds Senate majority for removal to prevent partisanship, so that removal only occurs after the House convinces its own members, the Senate, and the American people. The Watergate investigation, for example, convinced Americans that President Nixon committed crimes, forcing his resignation with overwhelming support for removal in the House and the Senate. In the case against President Trump, the House declined to call witnesses it felt relevant, arguing that the courts would take too long and the president was an imminent threat to our republic. House managers blamed legal resistance from the administration of witnesses. For example, Dr. Charles Kupperman threatened to sue. A congressional committee afraid of being sued while claiming to be fearlessly pursuing truth for the good of the country rings hollow. It also rang hollow when Adam Schiff said that we could not wait for the next election for voters to decide President Trump's fate after Speaker Nancy Pelosi held the articles for 37 days. That decision smacks of partisan political motivations. The partisanship the founders warned against was reflected in the House vote, with the only bipartisan votes being against impeachment. House managers Schiff, Nadler, and Lofgren once said that party-line impeachment would divide the nation. They never explained why their opinions changed. The role of the Senate, though, is to judge the House's evidence. House managers stated their case was overwhelming and compelling. Having not pursued further witness testimony in building their case, the House managers demanded the Senate call witnesses the House did not call. Additional witnesses, however, would not have changed material facts, but allowing the House to poorly develop a case, sacrificing thoroughness for political timing, would have forever changed the dynamic of the chambers respective to each's role in the impeachment process. Should the Senate acquiesce in this manipulation of the process, it welcomes the House to use impeachment as a political weapon, whatever the merits of its case. Now, I've been speaking of procedure. I want to emphasize procedure matters. Justice Frank Furter once wrote, "The history of liberty has largely been the history of the observance of procedural safeguards. If the appropriate use of impeachment is to be preserved, procedural safeguards must be observed." Moving now to charges. In Article 2, House managers argued the president obstructed Congress for acting on the advice of legal counsel to resist subpoenas. The judiciary resolves disputes between the executive and legislative branches. The House should have exhausted judicial remedies before bringing this charge. I shall vote against Article 2. In Article 1, abuse of power, 3 issues must be addressed. 1, the legal standard of guilt by which to judge the president. 2, whether the president committed a crime, and if so, 3, whether that crime warrants removal from office. First, the standard of guilt was never established. Legal standards for conviction vary from the lower, more probable than not threshold, to the higher, which is beyond a reasonable doubt, which is used in criminal cases. Since House managers charged, quote, something akin to a crime, beyond a reasonable doubt seems most appropriate, the higher threshold. And as Senator Jay Rockefeller stated during President Clinton's impeachment, beyond a reasonable doubt means that it is proven to a moral certainty that the case is clear, that the case is concise. Second, House managers allege that the president held military aid to Ukraine to leverage an investigation into former Vice President Biden as a quid pro quo, although they did not charge President Trump with the crime of requiring a quid pro quo or of bribery. The president's defense team cast reasonable doubt on this allegation. For example, regarding the July 25th phone call, which was reported by the whistleblower and which triggered the House impeachment proceedings, the president raised the issue of corruption in Ukraine. President Trump has always been skeptical of foreign aid, and especially when he thinks it is wasted. Hunter Biden was mentioned, but no connection was made with the release of aid to Ukraine. Other defense arguments included that Ambassador Kurt Volker denied a connection between aid and corruption investigations. President Zelensky and Ukrainian officials denied feeling pressured. President Trump denied a quid pro quo to Ambassador Sondland and told Senator Ron Johnson when asked if there was some sort of arrangement, quote, "No way, I would never do that." And both aid to Ukraine was released before the statutory deadline, and a meeting between Presidents Trump and Zelensky occurred without an announced investigation. It's also important to note that the release of aid on September the 11th followed new Ukrainian anti-corruption measures, which included swearing in a reformed parliament and installing a new prosecutor general August 29th, and the newly established High Anti-Corruption Court meeting for the first time September the 5th. Now, the third issue regarding Article 1, abuse of power, is that the term is a nebulous one which does not define a specific crime. Contrast this with the impeachment of President Nixon, when the House drafted an article of impeachment alleging abuse of power, but which enumerated 5 specific criminal and non-criminal offenses against President Nixon. The Constitution speaks of treason, bribery, or other high crimes and misdemeanors. Because high crimes and misdemeanors are not specifically defined, it is reasonable to assume that the framers meant for impeachment to occur only if a crime approached levels as severe as treason and bribery. Since the House managers allege President Trump committed something akin to a crime in deciding whether abuse of power is a high crime or misdemeanor, the prudent decision is to apply the principle of lenity. This principle, relied upon by Supreme Court Chief Justice Marshall and Justice Frankfurter, says that if a law is ambiguous, it is better to narrowly interpret the words of a law in favor of the defendant. Now, although the preceding discussion finds that the House managers failed to prove their case beyond a shadow of a doubt, failed to define the crime, thereby invoking the principle of lenity, it is still a question that if a crime was committed, was it an impeachable crime? In 1998, then Democratic Congressman Ed Markey argued that even though President Clinton, as chief law enforcement officer of the land, lied under oath, the crime was not impeachable. The Senate agreed, establishing the precedent that to remove a president, the crime must reach a high threshold of severity. The allegation against President Trump was not proven beyond a reasonable doubt, and it does not meet that high threshold. I shall vote against Article 1. I end by speaking of the ramifications for our republic. In 1998, then Congressman Chuck Schumer said of the Clinton impeachment, quote, "I suspect history will show that we have lowered the bar on impeachment so much, we have broken the seal on this extreme penalty so cavalierly that it will be used as a routine tool to fight political battles. My fear is that when a Republican wins the White House, Democrats will demand payback." Mr. Schumer was a prophet. This must stop.